Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Hafiza binti Muhammad Asri, S56147 from K2. We present Individual Assignment 1, Business Law for the Semester 1, 2020-2021. Based on the question 11, Tan Sendian Berhad, who is manufactured, is a seller to Munir by sold 50 unit of stove, while BB is the customer to Munir, which is she buy one of the stove from Munir for her own purpose. So, in this question, Tan Sendian Berhad is a seller to Munir and BB is the third party to Tan Sendian Berhad. Tan Sendian Berhad and Munir. Munir and Tan Sendian Berhad made a contract under Sales of Goods Act 1957, or known as SOGA 1957, which is Tan Sendian Berhad was transferred the goods to Munir and the agreement is called Business-to-Business Agreement. If anything happened with the goods, Munir can sue Tan Sendian Berhad at small claim court, and Tan Sendian Berhad also can sue Munir because the remedies in SOGA 1957 is only against seller privity applies, which is only Munir and Tan Sendian Berhad can bring the action. For the BB against Munir, BB is applied to Consumer Protection Act 1999, or known as CPA 1999. Since CPA 1999 only can be applied to protect the consumer who is acquire or use the good or services for themselves or for household purpose. In that question, also mentioned that Munir has sold one of the stove to BB. So, BB can apply the CPA 1999 because she buy the stove for personal purpose. If Munir refused to give back her money, she can claim Munir at Consumer Claim Tribunal. Refer to the Consumer Protection Act 1999, BB can take an action against Munir, but she cannot take an action to Tan Sendian Berhad because BB made a contract of buying with Munir. She can take the action against Munir, the Tribunal for Customer Claim, which is she can claim the amount does not exceed 25,000 ringgit Malaysia. In Section 85 of Consumer Protection Act 1999, Tribunal's main purpose is to hear and determine claim relief by customer under the Act. In the Tribunal, the proceeding of court basically involve the legal trial. BB also can claim Munir under Section 67 of Consumer Protection Act 1999, which is deal with the product that caused the damage to property, personal injury, and death. She can claim Munir under Section 67, Column 4, which is mean by safety, that include the safety with respect to product comprise terrain, safety in context of risk damage to property, and safety in context of personal injury or death. Munir against Tan Sendian Berhad. Based on caveat emptor applies, we can say that Munir cannot take action against Tan Sendian Berhad since he did not check the quality of stove and make a purchases by only seeing the sample, even though the stove is corresponded with the sample. Munir cannot sue Tan Sendian Berhad because he did not check the goods before bought it. In implied condition under subsection 17(2)(a) until subsection 17(2)(c), buyer has a reasonable opportunities or time to compare the bulk with the sample, but Munir did not take that chance to compare it and make the confirmation without seeing the stove. Once Munir made the confirmation, the acceptance is deemed to have taken place. Since both parties is under seller privity of contract, which is when the third party is injured and result of the some defect, the buyer cannot sue the seller. Munir cannot sue Tan Sendirian Berhad when Bibi is having an injury caused by the exploded from stove that she was parked. So Munir remedy would be to sue Tan Sendirian Berhad under tort. That's all from me. Thank you.